start with the case of A.M.C. versus State of Florida. That'll be 15 minutes per side. The remaining two cases are civil cases. That'll be 20 minutes per side. Parties ready to go with A.M.C. versus State? Okay.
May it please the Court, I'd like to reserve some time for rebuttal.
Okay. How much?
2 minutes.
I'll try to keep track of it, but you have a clock.
The sole issue in this case is whether or not the trial court erred when she disregarded the recommendation of the Department of Juvenile Justice to sentence the child to a moderate risk of detention facility. It's our position that she, in fact, did err. The reasons she gave for the departure were the degree of violence, significant injury to the victim, psychological after effect of the victim, disregard for society's laws and norms, and the lack of any reasonable explanation or justification for the crime. At no point did she ever explain why the characteristics that the department chose to decide were insufficient to meet the needs of this child. Every reason she gave for the upward departure was considered by the department. In the case of DRB versus State, it's clear the court says when the department has taken into consideration these factors, the court needs to explain why these factors are insufficient to meet the needs of the child.
Let me interrupt you for just a second, if I can. You started out by saying she disregarded the recommendation of the PDR and of the DJJ in this matter. Did she disregard it, or did she consider it, but then decided that she needed to depart from that upward? Well, from my reading of it, it sounds like she read it, she considered it, and even in the rehearing indicated that she had read it and considered it.
She certainly did read it and consider it. By disregard, I just meant every item that they placed in there, such as the degree of violence, they said, we're doing this because of the degree of violence. She clearly disregarded their recommendation in that regard. She did consider it before, it wasn't blind disregard. She considered it, but to her, it didn't meet the stand, She didn't say, okay, well, I'm going to follow this. She chose not to. Maybe it's semantics on my part. She clearly considered it. She clearly read it.
She has to consider it, does she not?
Yes.
And if after considering it, if she finds that, based on the circumstances of the case, she wishes to deviate from that and, for example, upwardly depart, she's able to do that as long as she delineates the reasons as they relate vis-a-vis to the child in this matter.
To the child's needs, yes.
And one of the biggest things that she picked on or isolated on was the length of time of the commitment. But in my reading of the record, not the statutes, but the record, I don't see any reference in DJJ, in the report, or any place else as to how long the particular programs are, if they are.
Correct, and there was no evidence to support that for her finding. There wasn't any mention either by the state or by the department or even by the court as to what the levels are and why the moderate risk would be insufficient. That's one of the problems that we're bringing to the attention of the court, that there has to be evidence to support her finding. There wasn't evidence, that no one had presented the difference in lengths and times and why one would be more sufficient over the other.
Are there lengths of times, or is each commitment an indeterminate commitment under the statute?
There are maximum lengths of times.
By the charge. By the charge itself.
Correct, but also by the commitment level. A moderate risk commitment level, a level 6, if you will, that individual is generally going to be in there between 6 to 12 months, is my understanding. I've never seen it statutorily produced where it says that. That's just from my practicing and being told by the Department of Juvenile Justice and my experience with previous children that had been committed and been released in that amount of time period.
Well, I guess that's where I'm a little confused, and I don't want to take all your time, but my reading of the statute indicates that any commitment of a delinquent child to the department must be for an indeterminate period of time. I mean, that's essentially the words of the statute. Obviously, it's limited by the length of the offense, if it's a third-degree felony or whatever it is. But if it's for an indeterminate period of time, why does the length of whether it's a moderate or a level 8 make any difference?
It wouldn't seem like it would if they're both indeterminate periods of time. It wouldn't seem like there'd be, if it's indeterminate, there's no stated end. So it would seem like either or could be the same length of time. But either way, the record's depleted that information for how she could use that as a criteria. She never broke down the difference in the needs of the child vis-a-vis the programs. This isn't, she doesn't have to necessarily go through a grocery list when she does this, but she certainly needs to address what each program's going to do. And the only thing we have is a general statement that it's not long enough. But once again, there's no evidence to support the fact of the length because no one ever entered into the lengths of time that we're dealing with.
Didn't the judge also either find or suggest that it was a question of getting this kid away from society? In other words, making sure that he was away from the community entirely?
She said that the danger to public safety was our paramount concern, and that this longer program would address whatever issues the child might have. But the problem with that is she never made any finding as to what these issues are and why they would need a longer period of time if they would need any. And so
why does she need to be that specific? I mean, isn't it really just a matter of her evaluating the facts of the crime and the child's reaction to the crime and what would be the difference if the child were away from an opportunity to do this again for a period of time? Why isn't that enough?
Well, in this case, it's not enough because those factors were considered by the department in making the recommendation. And the court even points this out. But for the degree of the violence of this crime, everything else in this child's background was indicative of probation for this child. Everything. The department took into consideration the violent nature of this child and that he may need to be removed from society to have some form of punishment and to learn a lesson when they recommended the program. So according to DRB, when the departments consider the same criteria that the judge considers an upward departing, she has to firmly explain why the department's thoughts are insufficient, and she didn't do that.
That's A.M.C. versus state, I think, that you cited that explains that.
It's actually DRB, which cites to, I believe, A.M.C.
Well, it explains it to me. What do you think is defective in her explanation? I mean, I understand what she's saying.
I understand what she's saying, too. But
well, then why, on what basis would we reverse her? What would we say?
You would say that she didn't go over the needs of the child for the program vis-a-vis, item for item, like she...
Why does she have to do that? Why isn't it enough to say this one criteria is the reason why I want this child in a high-risk program rather than a moderate-risk program?
Because the court says she can't.
Well, tell me what court says that she can't do that. That she can only... That all she has to say is the one thing. Your recommendation of medium risk isn't sufficient because this child, both in the nature of the crime and in the child's behavior afterwards, is such that it is clear to me that for the child's rehabilitation and for the safety of the community, he can't go to a community-based program. He's got to go to an incarcerative program.
Level 6 is incarcerative program.
Well, it allows access to the community. That's what she said. Correct. And that's what she said. I'm not letting him go someplace where he's got access to the community. He's got to go someplace where he can deal with this problem that he's got, whatever it is, without having access to the community. I mean, she says all of that.
Well,
why is that defective as a matter of law?
It's effective because, one, it's not supported by the evidence. Two, it's effective because the department took into consideration these same criteria, and she doesn't explain why the department's recommendation is insufficient. She never explains that, and that's why it's defective. The main issue here, and when she was sentencing every one of her reasons, it was much more like an adult upward departure. These are all valid reasons for an adult upward departure. Juvenile is a little different. Juvenile, you have to look at the needs of the child. And in this particular case, the needs of the child wasn't looked at. It was mostly the needs of the victim that was looked at. And granted, that can be taken into consideration, but this is taken into consideration overriding the needs of the child. She even said many times that, this is the psychological well-being of the victim. The victim needs time, so he's not looking over his shoulder. And those are factors that can be considered, but they can't be outweighed by the needs of the child because primary goal in the juvenile system is still to rehabilitate the child. And everyone else that looked at this, the department, the psychological review, the first time she made her disposition was previous to having the department psychological review. Psychological review goes in and looks at it and says, well, he's not appropriate for a level 8 program. That's just not appropriate for him to meet his needs. So every bit of extrinsic evidence that was offered to the court doesn't support her finding of upward departure. It really seems to base solely on the degree of violence with the crime and the after effects of what happened to the victim, which obviously is taken into consideration, was taken into consideration by the department, because if you look at the transcript, the first thing the department says is that based on the degree of the crime, we're recommending a moderate risk facility program. And that's really, she never goes into any detail of why that isn't sufficient. And it's really paramount to look at the needs of the child, and that wasn't looked at. At the resentencing, her redisposition of the preacher from Calvary Chapel, the church he went to, testified these were anomalies. This is something that, this child didn't have a violent history, had never been under supervision before, had never committed a crime of this nature, did well in school, wasn't truant, listened to his parents, did all his chores. All the criteria that we usually look at in determining, where to place a child, this child would have been on probation, but for the severity of the crime. That's the only thing that even got him into a residential program to begin with. And so then to go to the next step and to put him in a higher residential program, she really needs to look at the needs of this child, and everything she had before her was such that the needs of this child would have been best served in a moderate risk facility program. The needs of the victim clearly were better served with longer incarceration. And that certainly seems was the overriding principle, is that, degree of violence, significant injury to the victim, psychological after effects of the victim. That seems to be mainly where she hung her hat. And in juvenile, it's a little different than adult court. And this was a juvenile case. Therefore, the law is pretty clear. She has to enunciate her reasons. They have to be supported by preponderance of the evidence. And she has to list the characteristics that are needed for the upward departure vis-a-vis the child's needs.
Is the bottom line what you're saying, if I understand it, is that the primary reason you see that the judge upwardly departed was because of the length of commitment, and there was no basis in the evidence to commit for longer than the moderate risk program, indeterminate by the side, and secondly, that she could not upwardly depart based on the victim's interest. It would have to be based on the child's interests.
She can take the victim's interest into account. We're not saying that that can't be considered. She can take that into account. But the needs of the child are still the primary purpose in the juvenile system. And she wasn't considering the needs of the child, because if you look at the PDR, the needs of the child would have been met at a level 6. And I'd like to reserve the remainder of my time for that.
May it please the Court, my name is Rebecca McGuigan, and I represent the state in this matter. To answer your question, Judge Cass, I don't know what the statutory authority for it is, but the trial judge in this case referenced the fact that the child in this case was almost 17 at the time of sentencing, and under the level 6, the maximum time they can be committed in a level 6 program is the age of 19, and the maximum level under level 7 is the age of 22. There's a substantial difference amount of time between the two, and therefore the trial court referenced the characteristics of the different level programs vis-a-vis the needs of the child, which is what he's saying she didn't do here. You can find that in the record at page 163.
This child was never adjudicated show, was it?
I'm sorry?
This child was never adjudicated as a serious or habitual offender under the statute, which would have allowed her to extend the time.
No. I don't know what the statutory authority is. If you look at the record, it's in the commitment orders, all of them, that in a level 8, the high-risk facilities, the maximum time that they can be kept is until they're 22. So it's a substantial amount of time that she can keep jurisdiction over the child If she releases him from the program after he turns 19, then they have to let him, they can't keep him until he's 22. As soon as she lets him go from the program after he turns 19, her jurisdiction would end. But if he's not progressing the way he needed, she'd have more time to work with the specific needs of the child.
To release him at any time, they would have to at least notify the judge, and the judge would have the opportunity to object to that.
Correct. And then the other point that I wanted to make is that this is not an anomaly, first-time offense. He had another battery offense in Indiana. He wasn't on probation for that. He was on parental probation, but he did have a prior battery charge in his case. Other than that, it appears that this court understands the state's position. So if you have no questions, then we'll rely on our brief and ask that you affirm.
Once again, the record, as far as any evidence that was presented to the judge, to the length of time from the department, it's empty, it's silent. There's opposing counsel candidly admitted she's not aware of the statutory authority. I'm not aware of the statutory authority. I don't know where it's listed the exact amount of time, but I know it wasn't presented in evidence, and that's not something that was before that court. It has to be grounded in evidence, and it wasn't.
Well, there's a significant your opposing counsel brought up a very significant point. If the trial judge felt that by sending him to a level 8 program, that she would have more authority over him for an extended period of time statutorily, which would not have been available under a level 6, there may well be a well-founded reason. But she, at least my reading of the record is, she never adjudicated him under the show statutes, serious or habitual offender.
He wasn't eligible for it.
Okay. Without that, does jurisdiction extend past age 19? Does she have a legal basis to extend that time? Because she's enunciated that basis. The question is, does she have the ability to do that?
In a level 6 program?
About a level 8.
From what I've seen in the courtroom, they do it on level 8s. So I assume it, but once again, I'm not aware of the statutory authority that grants her that. I do know it wasn't argued in the case. I know that the record's silent as to that. The Department of Juvenile Justice never did it. The main point here is that she relied on a factor that the department relied on, which is the degree of this crime. It's the strongest thing that really overrode everything.
But you would agree that if the level 8 commitment involved a longer period of jurisdiction over the child, that she did articulate that reason, which addresses the needs of the child, and that is a longer period for rehabilitation.
She didn't explain why the child needed a longer period of rehabilitation. This is the whole problem. She didn't address the fact that she said whatever issues you have will be resolved. She never made any findings that there were issues. This is the whole point.
Well, I think it's obvious that there are issues when you look at the nature of the...
Correct, and that's what was taken into consideration when it asked for a residential commitment facility to begin with.
Doesn't she at 108 say, in considering that, I had determined that the longer period of a level 8 high-risk program was the most appropriate?
Correct, she says that. But to your first question to me about aren't they all indeterminate amount of times, and my response was, through practice, I didn't think so, but I'm not aware of the statutory authority. That evidence was never presented. The department never said this is this and this is this. It's not on the record why. She makes a statement, but it's not supported by the record.
Okay, your time has expired. Thank you, counsel.
Thank you.